Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy, powered by TrustArc. Here are your hosts, Dr. Kay Royal and Paul Breitbart.
After a short break due to summer holidays and some tech issues, here we are again. And this week we'll talk to you about international transfers. And it wasn't even planned. However, with the Dutch Data Protection Authority issuing their largest fine ever to Uber, 290 million euros for illegal data transfers, how could we not talk about it? Also in this episode, the ECCBDFCM will tell you what the acronym means and what you should do with it, and also a big shout out to Phil Lee. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy.
So Kay, I'm back.
You're back! Paul was doing the I'm back kind of thing, which was really cool. So, all right, let's see what kind of unexpected question I have. While you were gone, Violet and I had a lot of fun.
I had a lot of fun too, actually, just doing, well, nothing is not the right word, but doing all kinds of things not data protection related and staying offline for the most part.
Awesome. So very awesome. So I pulled up a new site for funny and weird interview questions. And the first one, I don't think we can go here, is how would you solve problems if you were from Mars? We're not going with that question. Let's go with the second questions. What do you think of garden gnomes? Do you have gnomes?
Oh, I don't like them.
You don't like garden gnomes?
No, I don't. In general, I feel they're very kitschy and they're just for a different generation, I guess.
I should show you the only one I have bought for myself, which was a striped one with big butterfly wings. Now that I'm thinking about it, maybe they meant it to be bumblebee, but it doesn't have bumblebee wings. It has butterfly wings. But my daughter insisted on buying gnomes for my husband, like every holiday that there's gifting, like birthdays and Christmas. She would buy him a garden gnome. And it turned out that when one of my good friends' house burned down, she admitted to people that she secretly collects gnomes. So we all banded together to buy her a bunch of gnomes to replace her collection. And it turns out that her son found a bunch of them hidden under cabinets and rubble that had collapsed and was able to save a lot of them. And her husband was like, no, we don't need to save them. We don't need to replenish her collection. We don't need gnomes. And she's like, I don't have as many gnomes as you do guns. He's a gun collector. He has hundreds. She's like, I don't need as many gnomes as you do guns. And he's like, yes, but I know where all my guns are. And they're all secured. So anyway, she's moving back into her house, rebuilt finally after the fire. And funny enough, it was not the fire that destroyed the house. It was the water. Her roof, her ceiling, her attic, whatever, above her head when she was in her office, her son walked into the kitchen, which is right outside her office one evening, between Christmas and New Year's or right at Christmas. Must have been after Christmas, before New Year's. And said, something smells funny. Turns out something was on fire in the attic. So the fire people came and they put out the fire and they left. Didn't destroy the house, just have to do some attic work. Well, then it caught back on fire like 2 hours later. And they had to come back and put it out again. And they left again, just attic work needs to be redone, whatever, blah, blah, blah. The third time they had to come out the next morning, They said this fire ain't coming back. So they flooded the entire ceiling and attic with everything from one end of the house to the other, which of course ruined the entire house because the ceiling collapsed and the walls were soaked and everything else. So it wasn't the fire that ruined it. It was the firemen determined that the fire wasn't coming back.
And I mean, to a certain extent, it makes sense, right?
It does make sense. It makes a lot of sense. So it's been a while. So it was interesting that the whole house was destroyed, but the structure was still standing because, of course, in Phoenix, it was brick or adobe. So the entire outside structure and windows were still standing. So the house looked like it was still there, but it wasn't. It wasn't. So let's go on to something happier. Let's talk about something with privacy or data protection or enforcement action or something. What you got for me?
Well, I'm not sure whether it's happier, but Uber got fined 290 million euros by the Dutch DPA, the largest fine in the Dutch history. And yes, it is a pretty big fine. This is a result of...
What did they do?
Well, they transferred personal data to the United States. Shocker.
Shocking.
Yes, and this was actually an investigation at the behest of the French Data Protection Authority, the CNIL, because a number of drivers for Uber, together with the Ligue des droits de l'homme et du citoyen, so a French NGO for civil rights, they filed a complaint with the CNIL on behalf of 21 Uber drivers. Later on, there were another 151 Uber drivers, so in total 172 who filed a complaint with the CNIL. And this was a complaint that was received by the CNIL in June of 2020 already, forwarded to the Dutch in January 2021. And basically the claim was of the drivers, hey, Uber is transferring personal data to the United States and there is no legal ground to do so. Because there is obviously, by then, we are talking the early 2020s, Schrems 2 had already happened, so the privacy shield no longer existed. Uber did not have standard contractual clauses in place, at least for part of the time. And that, according to the Dutch Data Protection Authority, meant that personal data was being transferred in a way that was illegal, in any case between August of 2021 and February of 2023. And for that, looking at Uber's global turnover, the Dutch DPA decided a fine of 290 million euros was in order. However, there is quite a few questions being raised in the report, at least the part that has been made public, related to international data transfers. And you can also read what Uber has claimed in defense for their position. And I must say that the Dutch DPA does not really do a really good job in explaining why Uber is wrong. There is, of course, the question, okay, do we need a data transfer mechanism? And before we go there, there is the whole question of Article 3 versus Chapter 5 of the GDPR. We discussed that before. We have the territorial scope of the GDPR, and if you are offering goods and services to people in the European Union, yada, 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 you are subject to the GDPR in full for those elements that are being processed from those people that are physically in the European Union.
And clearly Uber is soliciting drivers, if not directly soliciting riders.
Exactly. So there is, without a doubt, Uber BV is established in the European Union. That's the European headquarters based in Amsterdam. UTI, Uber Technologies Incorporated, is based in the US. They are a joint controller with the Dutch entity.
Okay,
and
hold
they
on.
do all
That's
the
a really
technology.
bad name. That's a really bad name. UTI? Really?
UTI.
UTI.
Well, at least that's the abbreviation that the Dutch use. I'm not sure whether that's the official abbreviation, but yes, Uber Technologies Incorporated. So they are based in the US. They are responsible for basically the whole tech platform that Uber uses. Uber says, well, we are joint controllers, Uber BV, Uber Technologies. Uber Technologies is an American entity, but they are directly subject to the GDPR under Article 3. So, by virtue of that, Chapter 5 does not apply because there is no data transfer, there is no data exporter, and there is no data importer because we are both entities under the GDPR. The Dutch GPA says, no, that's not true, because even if the GDPR applies, Chapter 5 is intended to offer additional safeguards. So if the entity is established abroad, then there is always a data transfer. See the guidance of the EDPB, and we see Uber BV as the data exporter, Uber Technologies as the data importer, and so you have a transfer. No matter if there is direct connection from the driver to Uber Technologies or not. And I just can't follow the logic. I can follow the logic of the argument, but I can't follow the steps that they are taking. They just state the fact there is a data exporter. They don't explain why. They don't explain why they consider, at least not in full detail, why they consider that if you are directly subject to the GDPR, that you would still need to comply with the data transfer requirements. This is the same discussion basically that we had when the opinion of the EDPB came out on cross-border transfers, and where also the EDPB was not very clear. And now there is a case with the opportunity to give full clarity here. The full clarity is not given.
Yeah. Because you can't enter into data transfer mechanisms with individuals.
No,
There's
cannot.
No standard contextual clauses. There's no binding corporate rules.
They are the data
binding
subject.
Corporate rules wouldn't apply, but yeah.
No, they are the data subject. So that's irrelevant. Also, that fact is nowhere recognized that the drivers are the data subject. Plus, even if you follow along with the whole argument, no, this was a cross-border data transfer, then Uber says, well, but there were no standard contractual clauses at some point. So that even if you accept that there is a cross-border data transfer and that Article 5 should apply, Uber then goes on to say, yeah, but the European Commission says that, no, let me take that back. So Uber says, well, we think that GDPR applies directly, and the European Commission has said for the new standard contractual clauses, if GDPR applies directly, you cannot use these standard contractual clauses. So that transfer mechanism.
So what do you do?
Is already out of the opportunities box. There was no adequacy because the privacy framework also was not yet available. And Uber says, well, if you really insist that we should have a transfer mechanism, then we want to rely upon the exceptions. And then there is the performance of a contract in the derogation section in Article 49. And there the Dutch GPA says, yes, but this is a continuous data transfer because it's ongoing and you cannot use that. Well, I think this will probably go back to the Court of Justice of the European Union.
You're damned if you do and damned if you don't.
Uber certainly disagrees, and they have already announced that they will appeal. Okay. And I'm pretty sure that the Dutch courts will forward this question, at least on what constitutes a transfer to the Court of Justice. And that's absolutely necessary because the relation between Article 3 and Chapter 5 that needs to come from the highest courts in the European Union.
Right.
My other problem with the case, apart from that it's not really well argued in my view, is the amount of the fine. It's 290 million euros. A lot. And you can say, well, it's a lot of money, but you can say, well, it's a serious contravention, it's data transfers. We are talking about a complaint of 172 drivers, but probably the Dutch EPA assessed all of the European drivers for whom this would have been the same.
None of which will get any of the money.
Of course not. What they never, ever even comment on is whether there was an actual problem with the level of data protection. Whether Uber did anything while the data was in the US to compromise the data. Whether it was not encrypted. Whether there were issues. So even the whole issue of possible safeguards is not discussed.
You would think that would be kind of important, wouldn't you?
Well, especially when you want to determine the seriousness of the infraction.
No harm, no foul.
Well, not
we don't
completely
know.
Because, there could be a foul because you are breaching the law by not having the required documentation. But does that require almost 300 million in fines?
Right. Now, how much of that is in U.S. dollars? That's got to be a lot more in U.S. dollars, right?
It's, I think, about 350.
290 million. What, euros? $2. I think you're probably right. You probably did 322.
Well,
That's a
there you
lot
go.
of money.
Yeah.
That's
It is
a
a lot
lot
of
of
money.
money. Especially
And-
without, as you said, we don't know if the Dutch DPA took anything else into consideration. Because as we mentioned before, and you in particular have a closer sight of it, they're not really good at putting all of their thoughts down on paper so we can actually follow what their rationale is so other companies can learn what to do right or wrong.
No,
So
and
we
there may
don't
be
know.
more reports that have not been released to the public. That's
Yeah.
certainly possible. I mean, we only get the summary of the analysis that's in the finding report that is public, and that's 48 pages.
Yeah. And I know one legal person with Uber. She's been there for a while now. She's pretty sharp when it comes to privacy and data protection. We've had her on the show, Ruby Zeffo.
Ruby Zeffo, yeah. And I mean, Salman Hania as well.
Yeah.
He is the European DPO. I have a terrific amount of respect for him.
So they got some big players taking care of this.
And also people who really take these issues seriously.
Yeah.
So I'm not convinced that this will stand. At the same time, I'm happy to see that there is finally something happening at the Dutch DPA. We see
Right.
reports now coming, and that has been a long time that we haven't seen them. But I would wish that they would make the reports more clear, more step by step, and just peel off every single element and not just skip a few steps like they seem to have done in this
Yeah.
case.
And
Undoubtedly
hopefully they
to be
didn't.
continued.
Hopefully they did not skip those steps. We're just not seeing them in documentation.
Well,
Yeah.
you say so.
I'm poly-optimistic. What do you call it? Pollyanna optimistic? I don't know what. Anyway, I'm going to go back and just say I'm always hopeful and optimistic about everything. You're the pessimist here.
That's true also
Well-
because I don't buy the legal argument. Because I would have made exactly the same argument as Uber did, saying,
Yeah.
hey, listen, we are directly subject to the GDPR, so we do not need a data
Right.
transfer mechanism, if only because there is no appropriate data transfer mechanism for that specific situation.
And
The European
between
Commission
consumers,
announced last year somewhere that they would create special standard contractual clauses for
that situation. Never have.
Never seen anything come from that. So,
Nope.
yeah, we'll see.
We'll see what happens there. What else do we have? I wanted to talk a little bit about the AI acts, although these aren't new. I think
Sure.
the new one is the California one that needs to pass the legislature in order to become law to hit Governor Newsom's desk. So we've been
September
watching it.
1st, right?
I'm not going to say we're following it, but we've been watching it. This is the California AI Act. By the time we go live with this show next week, it may be law, it may not be, but Senate Bill 1047, known as the Safe and Secure Innovation for Frontier Artificial Intelligence Models Act, which spells out nothing. You're going to give it a big long name like that. You need to do that, what do they call it? The backgram, so you can actually make it stand for something, but it doesn't. Yeah, the backronym. Thank you. So, but they didn't. So we don't have that one. But this is to deal with a lot of the AI startups, the researchers, the tech companies, the everything like this. So it says that it has to be passed and hit his desk by the end of the week, is my understanding. So we'll be watching this one. By the time it comes out, I'll put it in the show notes if it passes or not, so we have it. But I bring it up, not to discuss it in particular, but just to say there is still a lot of conversation out there about AI. And so far at this point, the only one we really have is the European AI Act, and then we have Colorado with AI. We do, however, have the Taiwan AI Act that is looking to pass. I think it's in the comment period now, the Taiwan's AI governance framework. It was open for comments between July 5th with a 60-day public consultation period ending 13 September. So it is a risk-based framework. For it, it does have potential content regulations for internet platforms. It definitely highlights data protection and intellectual property. So we really haven't dug into this yet. We'll talk about it more when we see what the comment period ends and where we go from there. But just wanted to point out that we don't have a lot of AI passed right now, but we do have a lot of AI movement. And hopefully we'll continue to see the movement. We do have the NIST AI governance framework in place as well as far as a little other. So I know a lot of you out there are struggling with trying to get your arms around AI at your companies. And so maybe
and
you
we,
have
of course, have Bill C-27 in Canada that's still pending, and where we are not sure whether that will actually make it into law, yes or no.
no idea. But while we're waiting on these to pass, because I mean, my big thing, and Paul and I did a big show on the EU AI, I believe. We did one, didn't we? Did we do
Not
one
a
on
full
the
one.
EU? We didn't do
No.
one. Okay. So Paul and I have discussed the EU AI Act. We haven't done Paul and I have discussed the EU AI Act. We haven't done a full show dedicated to it, but maybe closer to the end of the year, when we have a little bit more, we can start going through some of the AI acts that might apply to what you're doing. But we are cognizant that you are struggling with how to govern AI use at your company. Anyone who's not struggling, please let me know, because there doesn't seem to be a magical formula out there. We all seem to be trying to do what's right and what's ethical, committing to our ethical use of data, committing to not making, legally significant decisions for people based on automated AI processing, trying to make sure we're protecting the intellectual property, trying to make sure that we're building in ethics on it, trying to make sure that our data is not going out to their publicly trained platform to where everyone else benefits from what our data is. And if we all do that, there won't be any new data to train the models on, but we'll at least have our publicly owned ones to train our own models on. So we're all kind of struggling with the same things. We're feeling the pain. It looks like there might be some help coming down the road. But meanwhile, if you're subject to Europe or you're subject to Colorado or both, keep your eye on those, because those are the ones that we've got in place to follow right now. And then there are some frameworks and some good guidance out there. And by the way, update, no, I haven't scheduled going to get the AI GB. I haven't gone to get the AI certification yet. Fully planned to, went to look up to schedule it, and then the house started getting almost completed and I just haven't done it. So I'll keep y'all updated on that. I am watching the people who are posting all their resources online. And I have to tell you, my one thought is, wonder if I should go read some of these things.
Well, I am reading the EU AI Act because we are going into planning season for 2025, and 2026 is the hard deadline where the EU AI Act will apply, August 2026. Yeah. But a lot of requirements actually come before that. And given that every single company is working with AI right now,
whether you know you are or not.
Well, most of them luckily do know, but that also means that you need to look at what compliance requirements you have, because being compliant always requires resources, it requires documentation, it requires time. So now going into planning season, it is important to actually take a closer look. It's not an easy law, I can tell you. It's lengthy. There is a lot of cross-referencing. It almost feels like an American law with all the annexes and cross-references. And usually EU law is readable front to cover, and you have an understanding what you need to do. And now, but you need to look in Article 5 of that and Article 17 of that. And then you need to go to Annex 11 section to understand if this is covered, yes or no. So it's a big puzzle.
Well, and Phil Lee of Digifile, if I can give him a shout out here. If I can give him a shout out here. A shout out, right? We're going to start doing shout outs here. Phil Lee of Digifile has actually released some wonderful guidance on the EU AI Act. I'll make sure to link to his profile in the show notes. If you don't know Phil, you need to know Phil. Phil is a technician, a very technical guy, very technically savvy, that became a lawyer. And then he launched Field Fisher's U.S. Branch way back when I was working on him with BCRs when I was in Silicon Valley, and has since gone on and opened his own law firm. And I have to tell you, he is simply fantastic. There is no European lawyer I would put over using Phil Lee. Now, there's a lot of good ones out there. Please don't take insult there, but he's always had my back. and he releases some really good resources. So please go look that up. Like I said, I'll give you a link to his LinkedIn profile in here, maybe to his law firm as well, so you can look at those. And he also says that you can take his cartoons or any of the infographics that he releases as long as you give him some credit for it. They're all
can
free.
we give him some credit and get him on?
Ooh, that would be... Why have I not had Phil on the show?
Well, there's another shout out.
But no,
Okay,
that would
off
be
to
good.
China.
We should. On to China. China bad.
On to China. China bad.
China bad.
Well, China not so bad actually this week, because on August 27, the European Commission started negotiations with China, with the Cybersecurity Administration of China, for the so-called EU-China cross-border data flow communication mechanism. Now, there's an
a mouthful.
For you, the ECCBDFCM.
The ECBFFM.
So yes, not a very sexy name.
We do mock people that do the backronyms, but it's worse when you don't do a macronym.
Well,
Lord,
indeed.
This is going to be the European and China thingy. The new thingy.
Mm-hmm. So yes, this is indeed the new thingy.
Is it going anywhere?
Thingy. We don't know yet, because the discussions only started this week. Apparently, this is a deliverable from the EU-China digital dialogue that started back in 2023. But it is the intention to come up with some sort of arrangement between the two jurisdictions to allow for personal data to flow both ways. So from China to Europe and from Europe to China, in a way that is compliant with both GDPR and PIPL. Not completely sure how that would work in practice, but the negotiations or the discussions have started.
Be right back. Keep talking.
Somewhat worrying, though, is that the conversations are run by DG Trade and not by DG Justice. And of course, the free flow of data is important from a trade perspective, but it would be nice that also the unit that typically discusses adequacy or similar agreements with a third country, that they would actually also be involved in the negotiations. Well, maybe behind the scenes that is the case, but the lead is with DG Trade.
I love to see the EU and the China advancing in their discussions. We wondered what that was going to look back way back then. Probably in reaction at some level to the global CBPRs, because I think that's still a conversation that's happening. And so I think maybe that might have spurred Europe and China to maybe deepen their conversations, right?
It could be. I think this is also just a pure economic interest. I mean, let's be honest. There is a lot of business being done between Europe and China, whatever differences there may be. And that's impossible without data.
Exactly. And it's supposed to promote the free flow of data, although I think we've pretty much seen the exact opposite out of the GDPR. It's not really a free flow of data. And as a matter of fact, if you are flowing data freely, you're probably violating the GDPR.
Well, and that's the issue, because recital, I believe it's 100 or 100, and still states that data should flow freely around the world if protected, et cetera, But yeah.
You know, I'm going to look up which recital it is. At 100?
I think it's 101.
Must be, because 100 is certification in order to enhance transparency. So 101, there you go. General principles for international data transfers. Flows of personal data to and from countries outside the Union and international organizations are necessary for the expansion of international trade and international cooperation. I won't read the whole thing to you, except for point out most people, when they read the phrase international organizations, they think it means organizations who do business internationally. They don't mean that. They actually mean the big global organizations like Red Cross, United Nations, that have their own governing structure in place. Which, by the way, there was a job for chief privacy officer or something that was a conglomeration, PTF, FTP, something like that. And it was a whole bunch of those together for sustainable housing. I looked at it.
I haven't seen it.
Yeah,
but I was on vacation, so I have missed quite a few.
I'll have to see if I can send that to you when I see it, because I thought it was pretty fascinating, what they were looking at. Anyway, back to our regularly scheduled programming. So yes, so international organizations aren't quite what it means. So for the global organization, so just know that, this is just, as Paul says, economic considerations, because there's a lot of free trade between a lot of major corporations. I can't even talk. Between a lot of major companies, a lot of global powers. And we need to make sure that the data protection and privacy laws in those global powers can work together. The U.S. seems to be doing a not so shabbily horrible job at trying to get something done. But we all know we need to make sure there's cooperation in place with some of the other big major powers, China being one of them.
Yeah, I mean, we can't pretend that we're all isolated if we want to do business with each other. And doing business nowadays, whether we like it or not, also comes with data.
Always.
So understandable that trade agreements also talk about data protection, but I hope that also the privacy people will actually be left up to the trade people, so that we actually also get some decent protections that may actually also stand up in court.
Yes.
But on that international transfers note, somehow this has become an international data transfers episode.
It has become an international data transfer.
Yeah. We did not intend to have a full episode on transfers, but hey, somehow that's what it turned out.
Yes.
That's all for this week. If you want to join the conversation, join us on LinkedIn. You'll find us under Serious Privacy. You will find Kay on social media as Heart of Privacy and myself as Royal Paul B. Until next week, goodbye.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.